Okay, hi all, welcome back. Let's continue the discussion from where we have left in the previous class. So I think in the previous class we have discussed about the basic definition of the word contract. Contract means it is an agreement which is enforceable by law. We have seen all the sub elements of contract, what it contains and all that. So and also we have proven what we have proven, that we have proved this equation. So what is this equation? All agreements are not contracts, but essentially all contracts are agreements. So we have proven that one. So let's continue the discussion from there. So in this episode, we'll be seeing about the essentials of valid contract. So to call a particular contract as a valid contract, it has to satisfy all these essential points. So let us see all these things in detail now. So basically there are two categories here. So one is mentioned under, so this is essentials. It can be divided into two parts. One is what? As it is mentioned in section 10. So other part is not given under the Indian Contract Act, but still it is something essentials. So these points we will discuss now. So first we will be seeing this one. So what are the essentials of contract not given under section 10? First we will discuss this one. Then we will come back to this part. So these things let's see in detail. Yeah, the first thing is, so one of the basic essential conditions for a valid contract is there has to be two parties. So basically in a contract, minimum two parties has to be there. That only it is given here. So it will involve at least two parties. Maximum there is no limit, but at least it should contain two parties. And also a contract may be made by a natural persons. So natural person means a contract between you and me. So this is natural person. So if I enter into a contract with other than natural person, that is, say I enter into a contract with corporates or any type between B2B, those we call it as other persons. So other persons means these are other than natural persons. Okay, example it is given here. It can be companies, universities, or partnership firms, etc., etc. And also identity of the parties has to be ascertainable. Ascertainable means it is traceable. So which means the law says you cannot have a contract with a person whose identity cannot be traced. So basically it has to be ascertainable. So that is your first essential condition. See, the logic is very simple. Why two persons are needed? One person cannot enter into an agreement with himself. That is the basic sense here. Okay. Second thing, parties must intend to create legal obligation. So I think this is already discussed. So when we are discussing about this topic called enforceability, so we have already discussed this point in detail. So once again, we'll not spend much time here. Parties must intend to create legal relationship. So otherwise, basically, if there is an agreement, and if it does not give rise to legal obligation, so you cannot call it as an enforceable contract. This is already discussed. Social and domestic type, you cannot call it as contracts. Why? Because these are not enforceable. Yeah, husband and wife example, I think we have already seen in the previous class, but quickly I will run through this example. So a husband agreed to pay wife. Husband and wife, always problematic. Whenever husband and wife comes, they'll create a lot of problems. See, the moment you read this first line, husband and wife, that means this is a social agreement. Okay, which cannot be enforceable. Why? Because of this point, because they don't intend to create any kind of legal obligations. So this is already discussed, so we are not discussing it again here. This is a simple example. Example number 17. E solds good to B on a condition that he must pay for the amount. he must pay for the amount. Yes, it is giving rise to a legal obligation. So therefore, we can call it as valid agreement. Why? Because this is giving rise to legal obligation. I think it is already discussed. So let me move on to another point. So what is this other one? Other formalities to be complied with in certain cases. So what are those other formalities? A contract may be written or spoken. I think this is also a discussed point, but it is always advisable to have a contract in written form. Why? Because it is traceable. Because human beings, that's very common that if something is given in oral terms, so later on there cannot be a proof for that one. So therefore always it is advisable to have a contract in written form, because it is traceable, and not only that, it will serve as evidence. Yeah, the same thing is written here. And also fourth point, this also we have discussed in our first class, certainty of meaning. There has to be certainty of meaning. So let's consider this example. What do you mean by certainty of meaning? So here if you look at the example 8, it says A agrees to sell B 100 tons of oil. 100 tons of oil. Now the question is, what kind of oil? See, we have a lot of different kinds of oil. There can be a hair oil, it can be a face oil. So basically oil is a vague term. It is not defined properly. So therefore it is not certain. So when something is not certain, you cannot create a binding contract out of it. So therefore the one of the essentials of contracts is there shall be certainty of meaning. It should be clear what it is expressed in an agreement. It should be clear. That is what this point says. Yeah, example 19, if you look at it here, X Limited agrees to lease the land to Mr. A for indefinite years. Indefinite years. Again, it is not certain. Okay. So therefore, one of the essentials of a valid contract is missing here. Yeah, fifth one, possibility of performance of contract. There has to be a possibility of performance. We have a lot of agreements. Although it is valid, although it is legal, sometimes the possibility of performance will be lacking. So if the possibility of performance is not there, then you cannot call it as valid contract. So what it is, let's consider a simple example. We will get to know what this example 10 says. Here there is an agreement between A and B. A agrees with B to discover treasure by magic. Yeah, the question is it possible discovering treasure by magic? So it is not practically possible to perform this kind of acts. So therefore we cannot call it as a valid point, because physically it is not possible to prove this kind of scenarios. So that is why there has to be a possibility of performance. So these are very simple points. So basically we have completed this one. The one which is not given by section 10. So these are very general points. This we would have discussed in our previous lectures also. So I have quickly revised it. Yeah, now let us come to this section. So this section 10, it talks about the essentials which are exclusively given in the Indian Contract Act. So what are those things? We will quickly see it now. Yeah, so these are basically essential elements as mentioned in the Indian Contract Act. So basically it is mentioned in section 10. Let's discuss the first point, offer and acceptance. Offer and acceptance. I think this we have already discussed in our first class. So when we are discussing about the word agreement, agreement means it is set of promises. And what do you mean by promise? Promise is nothing but a proposal and its acceptance. So this is already a discussed thing. So we are not going to discuss it here again. Yeah, second one is free consent. So what do you mean by free consent? We will see it now. So basically in a contract, there has to be a free consent between two parties. So what is this free consent? So let's try to understand this one. So your first point says two or more persons are said to consent when they agree upon the same thing in same sense. Agreeing upon the same thing in same sense. So what do we mean by it? So let's look at this example so we can understand that point number one clearly. See here, A, who owns two cars. So A is the owner of two cars. Okay, out of the two cars, he is selling one car. What is that car? Okay, let me change this color also. Okay, he intends to sell his red color car to B. Okay, now B thinks he is purchasing the black color car. Black color car. So if you see here, A is selling a red color car, but B thinks he is purchasing a black color car. So therefore, two parties are not agreeing upon the same thing in same sense. So we cannot say there is a free consent existing in this case. So therefore, this becomes an invalid contract. So basically, this is your first point. And this is also called as consensus ad idem. Okay, two things agreeing upon the same thing in same sense, we call it as consensus ad idem. So let me call it as first equation. So basically your free consent had two parts. First one is consensus ad idem. Second one is here. The consent would be considered as free consent if it is not caused by CUFM. So basically this is your second point. So what is this CUFM? It will be discussed in the later chapters. So for now, C means coercion, U means undue influence, F is fraud, M is mistake, or M is misrepresentation, and the other M is for mistake. So basically if a consent is caused by any of this CUFM, then also there is no free consent. That means if you threaten or if you cause some kind of undue influence, taking advantage of your position, and if you cause that other person to enter into an agreement with you, so there is no free consent to it. So basically if there is no free consent, so one of the essentials of valid contract is lacking. So again the contract fails here. So let's consider this example here. Example 12, what it says, A threatened to shoot B if B does not lend him 2000. So if you see here, A threatened to shoot B. So that means here B's consent is not free. Okay, it is caused by one of the elements of CUFM. CUFM. Okay, let me minimize the screen. Yeah. Now if you see here, B's consent is not free. So therefore, free consent is missing. And if the free consent is missing, the contract becomes invalid. Contract becomes invalid. So that is about your free consent. So basically, your free consent has two parts. First one is there has to be consensus ad idem. Second one is it should not have been caused by CUFM. So that is about the free consent. Third one is capacities to the parties. So let's discuss about the third essential point of under valid contracts, that is capacity of the parties. See here, capacity of the parties means we are concerned about the legal ability of the person. So when we have learnt that there has to be two parties in a contract. So out of that, if one party is minor, the other party is major, the contract becomes void. Why? Because one of the essentials is the contracts, the capacity to the contract means the legal ability. That means the parties in the contract should be majors. And what your section 11 says, it has given some conditions here. Section 11 has given certain conditions. So let's see all this conditions one by one. So every person is competent to enter into the contract. So basically, who satisfy all these points given in 1, 2 and 3. So first point is he is of the age of majority. That means every person should cross the age of majority. That means he should be more than 18 years of age. And second point, it says a person should be of sound mind. Sound mind means, in simple terms, he should have a capacity, he should have a rational mind while he is entering into an agreement. So that is your second point. Third point is he is not otherwise disqualified. See, sometimes what happens, if people with bad repute, people who have criminal proceedings, they are automatically disqualified. They will be disqualified from law. So these people also are not eligible to enter into a contract. So in short, capacity means, so basically it is a legal ability of the person. And also every person is competent if he satisfy the following 3 points. What is that? Age of majority is nothing but he should have been above 18 years of age. Second one is he should be a person of sound mind. Third one is he is not otherwise disqualified. So if a person satisfies these 3 conditions, so he becomes eligible to enter into a contract. Yeah, fourth point, fourth essential says there has to be a consideration. There has to be consideration. This we have already discussed, and also there is a separate chapter, unit number 2. So in detail we will discuss it there. So for now, what do we understand by the word consideration? It means something in return. It also means quid pro quo in legal terminology. And also there has to be some value for it. Okay, a valuable consideration in the eyes of law. Because the law should recognize that consideration means it shall contain some value. It need not be equal, it need not be adequate, but there has to be something in return. So in detail we will see it in unit number 2. So for now, consideration means, just remember, something in return. This also we have discussed in the first class. You remember set of promises forming consideration for each other. That means my promise is your consideration and your consideration is my promise. So this is already discussed in the first class. Now let's consider the next essential, that is lawful consideration and object. See, your consideration and object both should be lawful. See, sometimes what happens, your consideration can be illegal. If consideration is illegal, then you cannot call it as a legal contract, a valid contract. So what is that? We will see it in this example. See, A agrees to sell his house to B. A agrees to sell his house to B against 100 kgs of cocaine or drugs here. Now, if you see this here, A agrees to sell his house to B. So this is a valid contract, because the purpose of the contract is valid. But if you see this 100 kgs of cocaine, consideration part is something illegal. Cocaine of 100 kgs of cocaine, it is illegal. So therefore, if your consideration is illegal, your contract will be automatically invalid. So that is about lawful consideration and object. Yeah, next essential, sixth one, it says it is not expressly declared to be void. See, sometimes law will declare certain contracts to be void. So here, as per this point, agreement or a contract, it shouldn't have been declared already void by court of law. So what are those things? We will consider this example. Threat to commit murder, or publishing defamatory statements, or agreements which are opposed to public policy. See, all these things in detail, it will be discussed in unit number 6. Unit number 6, all these things we will discuss in detail. So for now, it shouldn't have been declared to be void. This much you can take note of it. Committing a murder or publishing defamatory statements, so all these are something against public policy. So those which are against public policy, this will be always declared to be void by court of law. Say for example, another simple example I'll give you. A and B entered into a contract, okay, to destroy a BMTC vehicle, BMTC bus. So here if you see this contract, to destroy a public property is against public policy, so therefore this kind of contracts are considered as void by court of law. So in detail we will discuss this in unit number 6. Yeah, so basically this is about your essentials of valid contract. So let me go back to the initial table. So essentials of valid contracts. One which is not given under section 10, the other things are given under section 10. So all these things we have completed. In the next class, we will be seeing about the types of contracts. In the next class, we will be seeing types of contracts. So for now, what we have completed, first thing is the definition part, contract, what it includes and all the sub elements, and after that we have discussed in detail about the essentials of a valid contract, the one which is given under section 10, and those points which are those things which are not mentioned also we have covered in detail. Okay, see you all in the next episode. Till then, you can revise these chapters, especially those students who are missing in the first, second or third class. This videos will be really helpful for you. Please do revise and come. So let's continue the discussion from the next class onwards.